Right out the gate, this isn't just confusion, it's controlled positioning. The moment the negative private DNA result is mentioned, you can feel the shift from uncertainty to calculated next steps.
We did a private DNA test. It was through the DDC. It looks kind of like ours. Apparently in Ohio, through any lab test now, that shows that DNA is negative.
So once that DNA test comes back negative, is that when I would go ahead and put the other father, or can I go ahead and start that process since we already know?
Yes, sir. I'm right here.
Thank you. And try to find the spot, don't move around because I don't want you to lose that cell signal, sir. Okay. Here we go. All right, folks, we're on this is Bell 25 DFAM 352,262. This is in the 264th Judicial District Court of Bell County, Texas. As in the interest of early minor child, non-custodial party is Jakari L. Early, custodial party is Marche D. Green, and this matters before the court on a original petition and suit affecting parent-child relationship with an announced paternity. The court will note for the record that both parties signed requests for hearings, which pushed them properly before the court without any service citation. And so at this time, we can go ahead and proceed at this point. And I'll ask the state for an opening to tell the court what the state's requesting we do here today. And I think my assistant explained this may be the case. I'm thinking it is. I want to confirm that this may be the one dealing with private DNA. So at this time, Mr. Welch, I'll let you go ahead and proceed. Thank you.
Correct, Your Honor. This is the case with the private DNA. So there's an acknowledgement of paternity in this case. It was already filed with the court, and the state asked the court to take judicial notice of it.
All right, it's attached to the pleadings. Let me see.
Yes, Your Honor.
Okay. All right. So not very thick, so. All right, yes, the court will take judicial notice of the filing of exhibit number A with the original petition that shows announced paternity entered into and signed off on by the parties back in, looks like October of 2020.
Thank you, Your Honor. So Jay understands that the parties apparently, or at least the father, Mr. Early, and the child, Jakai Early, they did a private DNA test. It was through the DDC. It looks kind of like ours. Apparently in Ohio, through any lab test now, that shows that DNA is negative. Now, Your Honor,
is it a dual draw or just a parental draw? I'm sorry, a father draw only.
It's a father only.
Okay, all right, you may proceed.
And Your Honor, the reason I didn't, offer it or put into evidence is because I didn't want to get the docket confused. And I think they all agree that it's there anyway. So, Your Honor, the state has to object to the ordering of DNA, which is what Ms. Green and Mr. Early would like.
Right.
But I'm not going to strongly object, Your Honor.
Well, and the court's always going to do what's in the best interest of the child. It's best interest of the child to know who the child's father is. So I'm going to go ahead and grant the some brand new DNA testing. Obviously, I want mom drawn, I want the child drawn, I want dad drawn. But until then, I'm just going to do a DNA test. I'm not going to set up any temporary order, and we're going to get a chain of custody that gets us through all the legal requirements. And in the interim, ma'am, if you can get with the state, back with the state, with who the proper party might be, we can go ahead and start getting. They can start getting the necessary paperwork filed. So at this time, Mr. Early and Ms. Green, I'm going to go ahead and grant this brand new paternity test on this because this is in your child's best interest for me to do so. And we'll get it set up and get y'all reset probably somewhere 6 to 8 weeks out and get that results back. And if it's still the same, then obviously we will find that Mr. Early's not the father and move on from there, ma'am. Okay. I'll start with you, ma'am. Ms. Green, any questions?
So once that DNA test comes back negative, is that when I would go ahead and put the other father, or can I go ahead and start that process since we already know?
That's probably you can already let the state know who you know the father is, and they can start getting ready. Because again, this is if you recall, this time it probably took 2 to 3, 4 months for this to get to court to begin with. So let's get a jump on that one, because we know we've got a pretty good idea it's going to come back negative. But again, folks, ma'am, I've been all last week I was fooling around with AI, and I can get AI that shows that I was the #1 draft pick for the Dallas Cowboys in 1975. Okay, and I guarantee you I was not. All right.
Okay.
So yeah. So anyway, let's go ahead and get that set up and get the chain of custody. They'll get us to point A, from point A to point B. And Mr. Welch, if y'all, it's not against y'all's policy to start getting that information together so we can get this because like I said, the child in this matter is what now he's going to be 3, he's going to be 2 in October. So yeah, let's try to get this going where we can get the right party in here. All right.
Yes, Your Honor. And ma'am, I don't know if we already sent this to you, but we'll send you a form, attorney information gathering form, and you can give us information about the true biological father if Mr. Early isn't the father. So we'll get that going joint, and then file a new plating, I guess, with the new father, probably. So all right, and then Your Honor, for the reset date,
I see something about is Mr. Early still in Ohio?
No, sorry, I don't mean to interrupt, but no, sir, I never took the test in Ohio. I believe that's just where they
Oh, okay.
I don't know yet.
Where are you located?
I had the test done in Harker Heights, Texas.
Okay, yeah, I use the same facility you did. Both of y'all are local, so
Yes.
Mr. Welch, look at setting this one out about somewhere between 40 and 45 days and 60 days, because they're both local. We get that draw done ASAP and get that one back before the court.
yes, Your Honor. All right. So Miss Green, Mr. Early, just wait in the breakout room. I'm going to, well, someone will send you a DNA order with the reset date and the Zoom code. And then assuming the test is negative, then we'll probably do an order.
The strategy becomes forward-facing. The focus isn't just proving non-paternity, it's preparing for the next legal move. The mother is already thinking ahead, asking about naming the real father. That reveals confidence in the outcome, and the judge encourages that momentum without committing to it.
Against paternity for Mr. Early or something else like that.
Yeah, we can find it that he's not dad. So yeah, it's not the first time this has happened. So and Mr. Welch, I'm not sure if y'all still able to do that. If y'all can right now check when to see the appointments that could be made locally for DNA testing, maybe even get that set up today before these folks get out of here. Okay.
Yes, Your Honor. And one of our DNA experts will come and talk to you. And she'll go through the ropes.
All right. See, back in the good old live days, they would be sitting here right in the courtroom, so we can get that done before y'all even left. So, but hopefully we can still can do the same thing online. All right. All right, folks. I'll go ahead and let the state get y'all set up. We'll see y'all in about somewhere between 6 and 8 weeks, and we will hopefully conclude this correctly. And like I said, ma'am, get started on the right person. All right. And I'll start. I'm sorry, Mr. I didn't give you the opportunity. You have any questions, sir?
No, sir.
And Ms. Green, do you have any other questions, ma'am?
No, sir, I don't.
All right, anything else, Mr. Welch?
No, Your Honor. Thank you.
All right, let's get everybody back into a breakout room, and we'll get you folks all the information y'all need, and then after that, y'all free to go, okay? Thank you very much, and we're off the record.
Thank you.
All right. Let's move y'all away.
The court so finds that Mr. Black is not the biological father of the children at this time. Bell County calls number 24 DFAM 3444. This is in the interest of Giddens' minor children. We're dealing with 2 twin little girls. Both of them look like they're going to be, 2 years old this year. Anyway, the non-custodial party is Danelle Black. The custodial party is Kristen Giddens, and this matters before the court. A petition established parent-child relationship. Let's see, there was a first amended petition filed, and we've been operating under a temporary order since looks like April of this year. Court will note the court did substitute Ms. Swartz in for Ms. Garcia in this matter as the ad litem. Anyway, I'll ask the state for an opening, and see what the state's requesting we do here today and what kind of agreements and contests we have at this time. Thank you.
Thank you, Your Honor. So I have reached out to Ms. Schwartz, and she communicated, or her paralegal communicated to me that they had no objection to proceeding without her. The reason for that is because we have negative DNA results. So would ask the court to do an order, and neither party, I believe, is going to dispute the negative DNA. So would ask the court to do an order adjudicating that Mr. Vinell Black is not the father, and then we would need to get some language avoiding out the obligation was created under the temporary order. So I'd seek the court's guidance on how the court would like that order to read.
All right, then, folks, I've got in my hand right now Stakes Exhibit number 1. This is the DNA test for both the twin little girls. Is there any reason I should not let Stakes 1 in at this time, Mr. Black or Ms. Giddens?
No, sir.
No.
All right, so Stakes 1 is admitted. Stakes 1 shows that Mr. Vinell Black is not the biological father of the child, Michaela. I think that may be how you pronounce it. And is not the biological child of the child, Melissa. Probably a paternity of both of these is 0%. So the court so finds that Mr. Black is not the biological father of the children at this time. I'll go ahead and order the prior order null and void. We're gonna do away with it. Let's see what the original order said. How did we get there? We did a job without a DNA test and AOP. Okay. Okay, the court did appoint Mr. Glass as the ad litem for Mr. Black, SCRA attorney. And did that original order did appoint Ms. Garcia. The party's married?
I don't believe so, Your Honor.
Okay, just want to make sure. All right, so what's the state asking for us to do here today, and what's the ad litem asking for us to do in behalf of his client? Thank you.
Well, Your Honor, so I'm requesting an order that adjudicates Mr. Black as not the father, and I'm seeking some guidance from the court as to how that order ought to read that voids out the temporary order.
At this time, the court finds that obviously he's not the parent in this child, the child in this matter. Court this time is you can non-suit it, we can dismiss it, we can do whatever is necessary, and there's no obligation going forward on this matter. So
my preference, Your Honor, is if I can draft an order that specifically makes a finding that Mr. Black is not the father.
Well, that's part 1 for sure. Yes.
Okay. So my preference, Your Honor, would be to include also in that non-adjudication order some kind of language that voids out the temporary order. But I guess I'm just seeking some guidance as to the form.
Well, again, Mr. Diamond, that's not my. I didn't do this for a living, and I figured the state has done more of these orders than I ever have. But the bottom line is, whatever the state wants to do as far as that order is concerned, I'll review it and see it. But again, we don't have a template for that, sir.
I understand, Your Honor.
Is anything that Mr. Glass is asking to be in the order, please?
Just that I'm released, Your Honor.
All right, that'll be part of the order. And again, the order of non-parentage, and if there's any unpaid child support in this matter, the court will forgive that, obviously. But anything that was done prior to that, then I can't undo because it was part of the court order, and it was a legitimate default hearing. So, anything else, Mr. Diamond?
No, that's it, Your Honor.
All right, so if there's anything, I said everything is suspended, child support, any type of access visitation, that's all gone bye-bye, and anything that's owed is dismissed. All right?
Yes, Your Honor.
The second case flips everything from possibility to finality. Once the official DNA shows 0% probability, the court doesn't hesitate. The alleged father is legally erased from the equation. No gray area, no partial responsibility. The judge wipes out obligations, child support, visitation, everything moving forward. That's the power of verified evidence. But there's a limit. Past orders remain untouched. That's a key legal boundary. The system can correct the future, but it doesn't rewrite the past. What's striking here is how quickly everything collapses once truth is confirmed. A full legal identity, Fatherhood is removed in minutes. That's the weight of getting it wrong and the importance of getting it right.